2-1. Everybody, good morning. Good morning. Thank you so much for coming and being here this morning. We are so privileged to have our First American Title partners to be here today. And we're so excited to learn about all the contract changes. And we have gone through some changes with different people before, but we had never had an actual attorney to be here. It's so great. And because we will have a lot of questions, if you don't mind, and with Shannon and Monica from First American Title. So I'm gonna hand it over to one of you to do a short introduction. Monica?
Yeah. Well, I'm already. Can you hear me?
Oh, you already have.
Yeah, I already have my.
Okay.
So thank you all so much for inviting us in today. Again, I'm from First American Title. Unfortunately, our business development manager, Brandon Mattingly, couldn't be here today because he broke his collarbone. So he had sent us in his stead, and well, I was going to be here anyway, but he sent us in his stead. I want to introduce Shannon King. She is our senior escrow officer at First American. She's been licensed for over 26 years and honestly hasn't seen, you couldn't ask her a question she hasn't seen and couldn't answer for you. So Shannon?
Yes, good morning. I'm Shannon King. I'm the branch manager of First American Title in South Lake West. We've got 3 escrow officers in our office. We've got 2 amazing assistants. And obviously we've got Brandon, who's our business development. It is so weird talking with the microphone. But yes, I've been with First American for 27 years. It's the only title company I've ever been with. So it is a great title company. We've been in business for over 135 years. If you close with First American, your buyers will get free title monitoring for as long as they live there. So with all the fraud and misfiled documents that's going around, just know that they'll have a peace of mind that they've got title monitoring. Okay. We also have Ron, which is a remote online notary that is offered to all of our sellers free of cost. And basically all they need to do is log onto a computer, a tablet, an iPhone. They can do it from their couch. They can do it from work, and they can do their signing digitally. We do have a few lenders that will allow a buyer to do a Ron, but those are very few and far between. So, but just know that if your sellers are out of state, out of town, on vacation,
Out of the country,
closing is not an issue. Yes, ma'am.
How about no social security out of the country? Can you do that too?
as long as they have a valid United States ID. So if they've got a driver's license, that they can show ID to the online
To the
notary.
notary.
It's a foreign passport.
As long as it's valid.
Okay.
Yeah. Now, if you're referring to the RON, the remote online notary, they have to be able to ask knowledge-based questions. Okay. So, and we don't know what those questions are going to be. I'm assuming they pull them from somebody's credit report, but what kind of vehicle did you have? What was your last property address? If they fail those questions, they have to wait 24 hours before they can take it again. If they fail it a second time, they can no longer do the remote online notary. We'll have to make other arrangements.
Okay, so the person has to know how to speak English.
Exactly. Yes. Now, we do have a lot of our printed material in 50 different languages. So if that's anything that you guys are interested in, you can get with myself, you can get with Monica, you can get with Brandon, we'll get you guys that. Also, we have locations in the Metroplex, but if you guys require a notary, right now we're covering those notary fees for buyers or for sellers, but we do like to offer the RONs first and foremost because they're just so convenient. It takes people longer to get to our office to do a signing than it would do to actually do their RON online. They're like 7 or 8 minutes. So it's a really convenient tool. But Teresa, thank you so much for having us.
No problem. So you're recommending Ron, even they're local in town, is that what you're saying?
If it's convenient for them. If you want to come into the office,
Well, they can be at work and sign on their work computer as long as they have a camera. So we're doing things to make it so convenient for your buyers and sellers because we want to make sure that the process is smooth as possible.
Okay.
Yeah.
Gotcha. Thank you.
yes, sir. They can do it from Canada. Are you asking if we're in Canada? Yes, they can. Yes. As long as they can answer the knowledge-based questions and you can get online. Yeah. It's almost like DocuSign, but they're in front of a notary on the computer.
I just did one for my seller who's in China,
Mhm.
and then we paid, I think $250 on that.
Oh, no, we cover that.
Yeah.
That's
that's
a
really
huge
good.
benefit for your
And
client.
also if you guys start to work with First American, you'll learn that we have a lot of services behind the scenes. People are working all hours of the night. Our Ron team, they're a team. They're not in our office. They actually have their own facility. They will do closings up until midnight.
So the wrong service is one of your office
It's
staff?
It's owned by us.
It's owned by First American. So we have a team. They're probably located out of Santa Ana, California, if I had to guess, but they could be in multiple different locations. But yes, it is owned by First American and it's our own group. So it's not like just 9 to 5, right? If they need to get online at a different time, they can do that. Okay. And I'll give it back to Monica.
Okay. So hopefully we are ready to get started at this point. I'm Monica Mattingly. I'm an attorney and escrow officer for First American Title. Brian Watts, who is our senior underwriting counsel, is also on the TREC broker lawyer committee, who he had firsthand knowledge of how they did these changes, why they did the changes. And he and I got together to do this presentation to give you guys kind of the background information so you understand what's happening in the contract and why they've made the changes. And hopefully you guys find them as positive as we have looking at them. So we'll go ahead and get started. So-
I'd say these changes made more sense than
The last set,
yeah, it was horrible that time, but this is better.
it is much better. Yes. Okay. So I have to start with our disclaimer. This presentation is not the opinion of TREC or the TREC broker lawyer committee, the respective members, or First American Title. This is training material only. Okay. So introduction. Our recent TREC contract changes are revisions prepared over the past year by the TREC broker lawyer committee, several changes recommended by the TREC Sunset Commission. Final recommendations were made by the broker lawyer committee in 2026, and they were adopted May 4th, 2026, and they were effective as of July. So similar changes are generally made to all 6 standard contracts unless a particular change is not relevant to the individual form. So the contract forms that were revised were the unimproved property contract, the 1 to 4 family residential contract, the new home contract, the new home contract completed construction, the farm and ranch contract, and the residential condominium contract. Okay. They also made revisions to the amendment, the addendum for seller's disclosure on lead-based paint, the seller's disclosure notice, the addendum for backup contract, and the addendum for property subject to the mandatory membership in a property owners association. Okay. The seller's disclosure about groundwater and surface water rights is a new form, and so is the seller's notice to buyer for removal of contingency under the backup addendum. Okay, so the effective dates are, like I said, July 1st, except for as noted. Some of the forms were effective as of May 28th. And that would be the addendum for seller's disclosure of information on lead-based paint and the seller's notice for buyer of removal of contingency under the addendum. You can find the forms directly on the TREC website now since everything is live and active. And make sure as of now, you guys are using those new forms. Okay, so yes, ma'am.
Question. So on the zip form, are they automatically updated already, or we have to take a look about the form, see which is old one or the new one?
So
Especially in the, I put the,
Template.
tablets, yes.
So can I answer that question?
Sure.
Okay, all the forms have been updated in TREC form, that if you start a new form, it's automatically the new changes. But if you use your template, you have to go into template to update, otherwise it will still bring the old form. Well, I read that. Gotcha.
Thank you.
most changes are the same for all the contracts. We're only going to review the 1 to 4 contract today because that's the one most of you guys use most frequently. And also it's the one that had the most changes to it. So you're going to see throughout my presentation, some of the language is going to be blue and underlined and the deleted text is going to be red and crossed out. So first thing they did was definitional changes. So option fee, earnest money, and contract are now lowercase because they are not defined terms. So any of the uppercase words are going to now be capitalized and defined. So listing broker is now seller's broker. Other broker is now buyer's broker. Notice under 7B is now seller's disclosure notice to differentiate it from the other notices. So paragraph 2B, improvements, now includes generators. Since it's more prevalent to have a generator attached to a house because of, God bless our Texas grid, with it constantly going down. A generator is now considered an improvement to the house. That way you guys don't have to put that in special provisions or think about putting that in the things that are transferring. So legal holiday is also now defined. The legal holidays are listed on the PowerPoint, but also I'll go over them with you. It's going to be New Year's Day, Martin Luther King Day, President's Day, Memorial Day, Emancipation Day in Texas, Independence Day, Labor Day, Veterans Day, Thanksgiving Day, the Friday after Thanksgiving, and Christmas Day. Now, the reason that is important is because that 3-day period for them to get their earnest and option in gets extended if it's due on a weekend or a legal holiday. And so they went ahead and defined those legal holidays for you guys. So that way there's not a question of, hey, do I have till the following, day that's a work day after the holiday or not? Okay. The state holidays that are excluded from that list of defined holidays are going to be Confederate Heroes Day, Texas Independence Day, the San Diego Day, Lyndon Baines Day, Johnson Day, Christmas Eve, December 26th, and other optional holidays like Good Friday and Rosh Hashanah. Okay. And also just to note, just because a title company might be closed because it's a Texas holiday does not mean that your, contract deadlines are extended. So, like I said, your deadlines for the earnest and option money are the ones that are actually affected by this. And it's going to be only the actual legal holidays that are now currently defined. Okay. So references to addendums in the contract that must be used were deleted. A list of required notices was also deleted, and the statutory disclosures and notices were moved to paragraph 22 in the new contract. So the seller's disclosure about groundwater and surface rights, that's a new disclosure. This paragraph establishes how and when to give the new seller's disclosure about groundwater rights. The reason for the change is the Texas Sunset Commission reviewed the TREC, and recommended that they go ahead and add this information in. Why this is important? Not most people do not know that you don't own your surface rights in Texas to your water. Okay, you can own a lake house and own all the way up to the lake house or the lake, and then you have an easement to access the lake, but you actually don't own that water that the lake is there, right? So also, if you guys have a giant pond on the property, there is a chance that your seller does not own that pond. The state of Texas does.
Where does the seller find that water right information? Because
we'll go over that in just a minute. Great question. Give me a chance to get there. Okay, so you're going to see on the screen, we have all of the new language. It's all in blue. So it gives all of the defined terms. It says when you have to notice and when you don't have to notice, and we'll go over that on the next screen. So there are 3 options to choose from when you're disclosing water rights. Buyer has already received the notice. Buyer has not received the notice. And seller is not required to deliver the notice because the list is true. So buyers receive the notice. That's pretty evident. You've given the notice, but buyer has not received the notice. So seller must deliver that seller's water disclosure to buyer within a specified time, and buyer can terminate the contract for any reason within 7 days after buyer receives the seller's water disclosure notice. So if you're required to give that notice, it's good to get it to them sooner rather than later to eliminate the time to go ahead and terminate the contract. Okay. Seller's not required to give seller's disclosure notice because all of the following are true. So that's going to be seller's not aware of water well on the property. Seller's not aware of a pond, lake, or water tank on the property. Seller's not aware of any certificate of adjudication, certified filing, or permit for surface water rights associated with the property administered by the Texas Commission on Environmental Quality. Seller's not aware of any groundwater rights to the property that have been severed, sold, or leased. And the property receives water only from the following municipalities. So it's going to be your city water. Okay. So to answer that question now about how they know, it's going to be the Texas Commission on Environmental Quality. They have a, we'll go over that soon. They have a whole commission that you have to go through. You have to send them a request. You have to get a permit. It's a lot to own the surface water rights. So this is what the actual new contract looks like. It talks about what groundwater is, what the groundwater district is, surface water rights, and what well water is. So, and then it also goes through and gives you check boxes to either mark, this is what's going on the contract or not. Okay. And then the last is the signature page. So definitions: groundwater is water percolating below the surface of the earth. So think what you would drill down to drill a well. Okay. Your surface water is anything that's on top of the land. So your water in lakes, rivers, creeks, streams, and bays. Your surface water rights, you can gain access to them and own them by permit, certified filing, or certificate of adjudication administered by the Texas Commission on Environmental Quality. They'll authorize the diversion, impoundment, or use of the surface water. Your groundwater districts are going to be your local municipalities and your city water. And your well water is the water you drill down to and you have a well directly on your property. Okay. So groundwater, and it's only to the extent known by seller, is whether the property is in a groundwater conservation district, if the seller is aware of water wells on the property, the total number of wells, if the well is capped, covered, plugged, or abandoned. You have to verify the well is owned and operated by the seller if there's a well on the property. And if it's not owned or operated by the seller, you have to identify who owns and operates that well, and whether the seller receives water from well off another property. And that comes into play when you have two adjoining parcels, like family owns it, and they have one well and it services both houses. So that's typically when you would run into that. And also if the seller relies on groundwater owned or leased from land outside the property. Okay. Surface water, you have to know if there's surface water rights associated with the property. Think that they went ahead and adjudicated and got their permits. You have to identify it by its permit, filing, or certification of an adjudication number. And if more than one person owns interest in that surface water, or if there's a pond, lake, or water tank on the property. Okay. Notices to the buyer and seller. The revised form adds educational notices also. They're regarding what the water rights are complex. Seller might not know about the water rights relating to their property. Water rights for the property may be held by others. Groundwater districts have different rules and regulations and may not have taxing authority. So, and also if the parties need or intend to reserve, accept, or convey the water rights. And if they do, you guys do need to consult an attorney before making the property transfer. Okay, any questions on water rights? Okay.
Sorry, I just put a piece of cookie in my mouth.
That's okay.
So my question, I don't think I actually got the clear answer to it because, so as a seller right now, sorry, my client just closed down a branch with a big pond on it.
Okay.
In May. He didn't receive any disclosure about that pound. Now he thinks he owns the pound, but so for him to find out about the rights to the water, he has to go to that Texas environmental something to apply for it or to verify.
Yeah, he would go there to at least verify the information, see if the prior seller had ever gone through the adjudication process to get the water rights. And if they didn't, he can actually go through and step through the process and apply to have those water rights.
So does that mean that every pond on a property, the owner has to go through the environmental community to get the right, or
they don't have to? So if you have a pond on your property, you get the use and enjoyment of it, right? So you can have cattle graze there and drink out of it, or use it, boat on it, whatever, however big the pond is and what they would have the ability to do. They have the use of it completely. They would run into trouble is if they decided to dam the creek that feeds the pond and then make the pond dry up. That would be something where they could get into some trouble because technically they don't own those water rights for the creek or the pond. Does that make sense? So if they wanted to do something like that, then they would go through and apply to own the water rights that are on the surface of their property, and then they could make the changes that they want to make for their property.
So we can assume that they don't have the right because most of the people don't have, they own the by Texas, whatever. So when they sell it, they can still say that we don't have the right, right?
Correct.
Oh, okay. Thank you.
You're welcome. Okay. So we're going to move on to broker compensation at this point. So paragraph 8B was removed about broker fees and the obligations. And paragraph 12 now has major changes made to the restructure of the broker compensation language. And in my opinion, I think it's made it a lot easier to understand than what was previously in the contract. So in 12A, they've removed broker fees that seller has agreed to pay and broker fees that buyer has agreed to pay. And they've made significant changes to make it easier to understand for buyers and sellers. So that's what the changes look like. Okay. Now, paragraph 12B contains all of the broker compensation provisions. So each party pays their broker pursuant to their separate written agreements, and any contributions under 12B1 and 12B2 do not change the party's obligation to pay those agreements. So you can see the new language up there in blue. So that means if your buyer has signed a buyer rep agreement with you and said they're going to pay 3%, and you can only get the seller to agree to pay 2% of that, that means your buyer is going to pay your 1% through, their side of the transaction. So the new language sets up where it's much easier to read, and they can either pay a percentage or an exact amount, and you check the box. So,
I have a question on that.
Sure.
On the title side of it. So because we don't know what buyer reps they have signed, right? So does the buyer rep supersede or does the contract supersede?
Well, the contract supersedes on what the seller is obligated to pay, but the buyer rep is in effect for that buyer and the buyer's agent's agreement, right? So if the contract says 2% and we receive a CDA that has a 3% commission, we need to then reach out to the agent and say, hey, is buyer paying that 1% or have you guys made a different agreement? Just to make sure we get you guys compensated properly, because we want to make sure you guys get paid. That's one of our number one priorities here, is to make sure you guys get paid properly. But it eliminates a lot of the confusion for the buyers and sellers with the new language. So the seller pays a specified amount or a percentage of the sales price to be applied toward the compensation owed by buyer to buyer's broker. And the buyer pays a specified amount or percentage for the sales price to be applied toward the brokerage compensation of the seller. And so why did they add 12B2? It's a great negotiation point for you guys. If you guys have a situation where the seller has multiple offers, it allows your buyer to say, hey, I'll pay 1% of your commission for your your agent. And that helps sweeten the deal, right? And also leaves the sales price, right? So then we're not fluctuating and paying less than what way more than what the house is worth. So paragraph 12C, if a governmental loan program regulation prohibits buyer from paying charges or fees, then anything in 12A1B concession shall be first applied to pay the prohibited expenses and then to other buyer expenses. And this does not apply to broker compensation or contribution. So if the buyer was prohibited from paying something, that new paragraph 12C would allow those fees to be distributed differently. So that way you guys could get those full credits that were offered. Okay. The language in the broker information page at the end of the contract that's provided for sharing commissions between brokers has now been removed. So paragraph 12 provides the only part for a direct distribution by seller or buyer for the party's broker. There's no provision for sharing compensation between brokers. And that change was in effect because it helps keep everything cleaner. Everything's in one paragraph, and then there's no confusion of what's being paid to the buyer broker, what's being paid to the seller broker. It's all in that one paragraph 12. Okay, so before we move on to some other contract changes, including governmental requirements, do you guys have any questions about broker comp? Okay, yes.
12C. Oh, sorry. Can you explain 12C again? Does that mean that if the broker's agent want to give some contribution to either the buyer or seller in the back, can they use 12C somehow? Because I don't remember there's a blank there that you can fill in a number or something. It's only 12B where you specify the numbers.
So 12B it gives the ability for that buyer to pay a specified amount to the seller.
Mm-hmm.
Okay, and 12B1 gives the place for the seller to pay a specified amount, either percentage or the exact amount to the seller. And then 12C, the new paragraph just says if a governmental loan program regulation prohibits buyer from paying charges or fees, then that 12(1)B concession shall be first applied to the prohibited expenses and then the buyer expenses. So think about like,
Oh, that's just an explanation.
Yes.
Okay, got you. Thank you.
Okay, so The other contract changes, they were broadened to apply to all governmental requirements, not just federal. So seller and buyer shall promptly execute and deliver any statements, documents, and information requested by the escrow officer required by a governmental reporting for a governmental reporting requirement. And all that paragraph 12 means is if we have like a mud district and it says that you guys have to sign, acknowledging that the house is in a mud district. This just gives you guys the ability to say, no, you guys have to sign this, because sometimes you have sellers that are like, oh, I don't want to sign, or a buyer that doesn't want to sign something. And that paragraph just gives you guys a little bit more leverage to go ahead and get people to sign the documents that we need signed. Okay, paragraph 21, the notices. It permits notices to the parties or their agents. It permits notices to be sent by overnight courier, and notices are now effective when sent to the other party or agent, not when they're received. So that's an important change. And also the paragraph was formatted for simplification. So why that is most important about the effective when sent. So if you're thinking about a termination notice and you go ahead and get it sent out by 4:50 p.m. and that buyer's agent doesn't, or the seller's agent doesn't get it until the next day, your notice is still effective. It's not effective when the other party receives it. It's effective when you give that notice. So that's an important change. Okay, other contract changes. So this is going to be that at the end of the contract, it lists out every single form that you guys would have to attach, and you guys get to mark those boxes now. And they've gone ahead and reorganize them so that way they make a little bit more sense. So it's financial, leases, additional tests and reports, disclosures, and others. So that way you guys can mark every single addendum that has to go along with the contract, and it's easier for you guys to find and read. Okay. So on that, notice is given that a seller's failure to provide the applicable statutory disclosures and notices may provide buyer with remedies and rights to terminate the contract. So that's why that list is important, because every single thing you guys are supposed to be giving along with the contract, you guys mark those boxes and make sure it's all sent together. Okay, this is the broker contact information page. It got reorganized. So if you notice on the presentation or also in your handout, it gives represents seller only as seller's agent and represents buyer only as buyer's agent, and then the bottom is an intermediary. Now you're only going to use the intermediary if you're the only agent on both sides, right? You're the agent who has found the buyer, they're not represented, and you're working with both parties, right? Everything else you guys are going to go ahead and list in the first two. So that new page provides separate sections for giving information for brokers representing seller only as seller's agent, brokers representing buyer only as buyer's agent, and then also as an intermediary. The language previously in the broker information page that provided for sharing of commissions has been completely removed. So only paragraph 12 is going to rule on how you guys are splitting commissions. Okay. Okay. Does anybody have any questions on broker compensation before we move on? All right, next is the farm and ranch contract. The agreement for payment of broker fees at the end of the contract is clarified to provide it will not be used if the contributions for payment are already provided under paragraph 12B. So they did make some changes toward the end of that on the broker fees, and that's what the changes are. Okay, so the amendment to the contract, the broker compensation. Paragraph 5 of the amendment is revised to be consistent with paragraph 12B of the contract. So now it reads exactly like that 12B does, again, just for simplification. Okay, the new seller's disclosure notice. The new disclosure was directed by the Sunset Advisory Committee to TREC. It includes whether the seller is aware of if there's a conservation easement on the property, if the property is presently covered by insurance, the property is presently covered by windstorm insurance, if the seller is unable to insure the property, or if there's a private road or adjoining the property that the seller is financially responsible for, or if there's any above ground or underground storage tanks on the property that hold over 500 gallons or more of petroleum products or other chemicals. Now, why this is important is if you're looking at getting to closing day and the buyer can't insure the property because it's uninsurable, this takes that out of the transaction, right? So if seller can't insure the property, obviously your buyer's not going to be able to insure the property either. I've only had that happen a couple of different times, but it's a good way to eliminate any other reasons to terminate the contract right before closing. Okay.
Can you give some example why the property cannot be insured?
Sure. Sometimes the last one that happened to me 3 or 4 months ago was the roof was it was on a trailer, and the roof was not the or normal regular shingle. It was the older, from like 1990 shingle that they used to be on trailers, and the insurance wouldn't insure the property unless the roof was replaced prior to closing. So there's other reasons too. Sometimes if it's in a significant like hail area and they've had too many claims on it, some insurance companies won't cover it. There's a good list of reasons sometimes. Yes, sir.
If you're representing a buyer and a house has the listing agent using an old form, can you force them to fill out the new one?
So if you're in a current contract situation, so
No
the
contract, it's just like I'm just like about to make an offer and then I see that this is an outdated one. Can I go call the listing agent and be like, hey, go put this in?
yes, you guys are required to use the new forms after July 1st. So absolutely force them to use the new forms. For sure.
That was my question too. If my seller filled up and signed the seller disclosure before May 28th, so do they need to fill out a new one?
No, if you guys are currently under contract, you can still use the old forms. It's anything that is going under contract after July 1st, you have to use the new forms. Now, if you have a concern and you're like on the buy side and you're like, hey, can you guys go ahead and fill out the new seller's disclosure form? I don't think that that's an odd request or out of the realm of what you guys should be able to ask for, but they're not required to. Okay, if you're currently under contract before July 1st, you can still use the old forms.
Under contract July 8th.
You guys should go, if you're under contract of July 8th, you guys should go back and execute the new contract. It's required.
Okay.
And
we
it-
need to get that changed.
You probably should, yes. Okay. Okay. So the other form that has been revised is going to be the addendum for backup contract. The term option money, earnest money, and contract are now in lowercase on the backup. The term legal holiday and effective date are capitalized because they're now defined terms. And paragraph H has also been revised to change the timing of the amended effective date. The amended effective date is now the date the seller delivers notice of the termination to the first contract buyer rather than the buyer receives the notice of the termination. Okay. Also, do we have any questions on that before I move on to the HOA? No? Okay, good. So they have gone ahead and made some changes, and I think they're good changes for the mandatory membership in a property owners association. If the buyer is responsible for obtaining the subdivision information, then buyer is not required to deliver a copy to the seller. So if you guys are in a contract situation where your buyer has been the one that has to pay to order the HOA resale package, they're not required to give that notice to the seller once they get it. Although if the seller has to do it, they still have to provide the notice to the buyer. Okay. The fees and deposits for reserves. If the cost allocation set out in the addendum differs from the resale certificate or the declaration, the contract is clarified to provide that in the case of discrepancies, the agreement between the seller and buyer controls. So what this means is what number you put in that addendum that says buyer will pay up to this amount, not to exceed $150. And then the HOA resale certificate comes in and says, hey, this is a buyer expense, this is a seller expense allocated. It does not matter what that HOA resale certificate says. Buyer is only going to be obligated to pay what's in that blank, okay? Unless it's a future assessment. So if they're saying, hey, we're closing on July 1st, and this is the next set of dues starting in September, obviously buyer has to pay those because it's not covered in this paragraph, okay? So think about when you have those situations where, and I always use Lantana as an example because it's the most ridiculous one I've ever seen. Lantana has a community enhancement fee. They have the school, I forget exactly what it's called, but it's their school assessment fee. And their HOA transfer fees are in excess of $7,000 typically.
What?
Yes. And so I know I don't let it scare you, but just know that Lantana specifically, it's a neighborhood in Flower Mound, that they have the highest HOA transfer fees I have ever seen. So that
How much?
7,000.
7,000. So because they have the community enhancement fee and then they have their school foundation that you pay, and it's typically another 1% of the sales price. And I think the last one I did was right around $7,000 because it's based on the sales price of the house. So that's really a good thing to be aware of when you guys are writing contracts, because your buyer is only going to be obligated to pay what's in that blank, and your seller has to have, pay the rest of those costs. So if you're a seller's agent, you can always reach out to us here at First American. Brandon is really our business development manager, who was unable to be here today because he has a broken collarbone. He is very good at pulling CC&Rs prior to you guys going under contract and can tell you what those HOA fees are going to be. So that way you guys can go ahead and be prepared when you guys are writing your contracts to know, hey, we want the buyer to pay this enhancement fee or this other fee that's part of this transfer. So that way your seller's not having to go through and pay all of those costs yourselves. Okay. I do have some of his cards over there on the side. If you guys want to pick one up, he is amazing. And I'm very sad he's not here today because he keeps me in check when I'm doing these presentations. So, okay. So the other new forms are going to be the seller's notice to buyer of removal of contingency under the backup contract. So you can see on the screen what that new form looks like. It also gives a spot for the option fee and the earnest money receipt. That's actually more helpful to us than it is to you guys. So now seller can use that form specifically to notify the buyer under a backup contract that their contract is now the primary contract. Seller notifies the backup buyer that the contract has been terminated. The backup contract is no longer subject to backup contingency and specifies the amended effective date. Okay. And then, like I said, they have receipted sections, but that's just for our benefit, not yours. Yes, ma'am.
So question, the old amendment for the backup contract is just saying that automatically it will become the blah, 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 you go with the back to the main contract. So since now we have this new form, does it mean that we have to submit this new form for the contingency to be removed, or it will still go back to the, if we don't have this form, it still goes back to
No, you guys should use the new form. Because it gives the deadlines for your notices now, right? And it gives deadlines for the contract to be effective. So, and as soon as that seller gives that notice, it automatically, and then there's no question of, hey, oh, well, I didn't know that it was, effective now. And it gives you a good set of deadlines for the effective date. Okay. That is it. That was all of the new changes that were done in the contract. Do you guys have any questions here? No? Do we have any questions from our online friends? We've got one back here. Oh, sorry.
Not a serious question, but this is like a lot of changes. Is this normal for a year? Is it like, how does normal?
Okay, so I'm going to preface this by saying nothing is normal in real estate, right? I mean, anybody who's been licensed for a bit has seen the COVID changes where people are offering $100,000 over asking price, and now our weird economy now where things are slower and not moving quite as quickly. So nothing's normal in real estate. But yes, I think all of the changes they were to clarify the prior changes. I noticed a lot of the changes they made this time fix the mistakes they made the last time, and then a couple additional new changes. And I think if they didn't have to fix those, in my opinion, prior mistakes, we would have had less changes on this contract. They would have just had the new addendums and reorganized things a little bit better. So, yes, ma'am.
Okay, I still want to clarify on the 12B. I still want to clarify on the 12B broker composition part. So there's a two checkbox. One is seller pay, one is buyer pay. You only can check one. Is that correct?
Well, you don't have to only check one, but it makes sense to only make
Only
one
check
choice,
one.
right? Yeah.
That's right. Okay.
So if you're looking at, like I said, again, a multiple offer situations where you want to sweeten the offer to the seller by having the buyer pay some compensation, that's when you would use the second paragraph. But if seller is going to pay part of the buyer's compensation, you're going to want to use that first paragraph and mark either the percentage or the amount and put that information in there.
Yeah, because after I read it carefully, I think, you only can either choose one or two. Choose both doesn't make any sense.
No.
Okay. I just want to clarify that.
No, you're good. I like the questions. I would rather you guys leave understanding than being more confused than before I got here. So do we have any other questions?
No?
No?
All right.
Okay.
Thank you so much. Thank you. you. For those of you who came in a little later, I just want to do another round of introduction. And this is Monica from First American Title, and that's Shannon King. Yeah, we worked together before. I just realized. Wait a minute, this is first time we face to face. We actually yes. Thank you so much for coming. And they brought great bagels and I just happened to be, I have a friend who brought in some freshly baked Beijing Daoxiangcun snacks. So please enjoy. But before y'all left, I just want to say that thank you so much for coming, and thank you all so much for coming. This is so important. That's why I push everyone to come to this training, because we have to stay compliant. That is literally the first and foremost thing we need to do. And thanks to the title company and attorney to be here. Otherwise, we'll be all in the dark. We have to figure out how to fill out these new forms. Like Jimmy said, this is a lot of changes. And I have been in real estate since 2008. Honestly, to me, normally, which is before 2023, 2024, there are not that many changes. And there are not that many changes for many, many years. But first set of changes came after COVID. I guess we had some changes to the law and to the forms, and then the most changes came in 2024. And that's actually one of the reasons why I joined EXP, because I feel like I need a bigger umbrella. With all these changes, being a broker owner on my own, I was scared. Like all these changes there, and you saw how terrible it was before.
Yes.
In 2024, all these changes came in, and it was so confusing. It was so confusing. So this time the changes are much better. They're clearer. We know it, even without a lot of the attorney changes, they all make a little bit more sense just by reading it. So this is a yeah, and I think it's coming. There might be still a little bit challenging, but I'm pretty sure. And I didn't know Brendan was on the committee. That's great. Yeah, he's still on.
Brian Watts is on.
Oh, Brian Watts.
Yes, he's our senior.
Brendan.
Yeah, he's our
Okay.
senior escrow underwriting counsel. He's actually on the broker lawyer committee. For those of you who guys missed me saying that at the beginning.
Yeah.
So we actually have a pretty good inside view of what happened and why, because he's our senior underwriting counsel and also on that broker lawyer committee.
Yeah, that's so important. So important. So if you have any questions, don't hesitate to ask, because this is important to get it right. Sometimes title company can change it. Once you get it signed, executed, they will just follow. They can't change it. And we're the one who are in the front line. We have to get it right. And that's important for our clients, for the other side, just for our own sanity. We need to know this is right. And also, don't just look at the TREC forms. And I have seen many changes just at the same time. When the TREC forms change, TRA forms, the TAR forms change too. All the listing agreement and what was the other one? The other thing that I just dealt with. Yeah, so lots of TAR changes. TRA forms, they all changed. So make sure that you go through the changes. Make sure that you study these changes, so that when you use the TAR changes, you see them, you can relate to the TREC changes. Unfortunately, we don't have a new website or something like TREC has on the TAR, but you can right now. Actually, I go to ChatGPT. It will help you to tell you all the changes. But thank you so much for being here, and we learn a lot from Monica and Shannon. Shannon, when you talk about the wrong business, did you see any new people coming after that, or you want to say a little bit more about
Discuss
your
the Ron.
service? Yeah.
So I was telling everyone earlier that we have our own Ron team. It's called the Remote Online Notarization. So if you have any sellers that are out of state, out of the country, at work, can't leave, anything like that, if you have two sellers that are in two separate spots, we offer the remote online notary. Those are free of charge. They have to be able to answer knowledge-based questions. If they pass that knowledge-based question, then they can get in. What they'll do is they'll upload a copy of their driver's license. They'll be put in a waiting room, and then the notary will come on, verify their identification, and then start the closing process. You guys are also invited to attend those RONs if you want to attend them, should you want to be there for your seller. If they don't answer the knowledge-based questions right the first time, they have to wait 24 hours before they can come back on and try it again. So just know that if you're going to offer that to them, that they know their last address, their last vehicle they owned, their last employment, things of that nature. And we don't know what those questions are going to be because they're pulled from their credit report.
It's one error. That's pretty strict.
Well, yeah, you have to answer I think it's 3 questions, I think.
But any one they answer wrong is one.
You have to wait. Yeah. Yeah.
And
Well,
that's,
it's
I mean,
kind
that's
of
true
a-
for any remote online notary.
Yeah.
service.
It's not
Yeah,
just
yeah.
for us. I
It's-
mean, that's
it's-
any.
It's there to protect sellers from fraud.
Yeah, it's a identity identification. So basically, it's like you're applying for a credit card or getting a car loan. They ask you these questions. You have to get it right. If you get it wrong, you don't get approved. So that's just the same process.
It's not as scary as Shannon made it seem. It doesn't happen.
It's
very
not.
often.
I just like to be
Can't
full
answer the question.
transparency. Like if you have any doubt in your mind that your seller might have a problem answering those questions, we might want to go with a notary versus a Ron.
Yeah.
Just saying.
Well, I've seen one question. They ask you the color of the car. You're like, it's a lot of cars.
I'll admit, sometimes when I get asked those questions, I have to look at my husband and go, which one was this one? Which one was this one? So they're easy, but they're just like we said, it's for their safety as well. So,
Yeah. Great.
okay.
Yeah, they have a lot of locations, offices, and online services. And I kind of like the fact that the seller doesn't have to go to the office to sign. I've had already a couple sellers, they can sign at home, just do remote signing. And buyers, a lot of times it's easier. They can, do remote signing too. So that's kind of makes it easy.
If you're buying cash, you don't even have to come into the office anymore anyway. We just do DocuSign if you're purchasing via cash. If you have a lender, your lender has to approve the remote online portion. We've got a couple of lenders there's 2 of them that do that I'm aware of. They're slowly getting on board for that. But what they're mainly doing right now are hybrid closings, where the buyer will sign half of their documents online, and then they come into our office to sign the other half of their documents. So it's really cut that closing time process in half, as well as the amount of paper that we have to print in half. So,
That's true. That's
yeah.
true.
but that's dependent on your lender.
And also, I know that you do 1031 exchange.
We do 1031 exchanges, and we also have a 1031 exchange department. So if any of you guys are interested in 1031 exchanges or a class on a 1031 exchange, we can set that up as well. If you just need a contact for a 1031 exchange, we can give you their contact info.
And you do commercial too.
I do, yes. I've been with First American for 27 years. It's been the only title company I've ever worked for. We've been around for over 135 years. And we have many, many resources and tools. So I highly recommend, if you're interested in visiting with Brandon, who is our fabulous sales rep, let's get you guys on the schedule for that. And he will go over all of those with you. You can farm a subdivision. You can do, I'm not even going to go into all that because we'll be here forever. So just get with Brandon on that, and he'll set up some one-on-one time with you guys. But thank you so much for having us. It was a pleasure.
Thank you so much. You're welcome.
Just to take up just a little bit more of your time and piggyback on what Shannon was saying with Brandon, he also does support packages for your listings, and he'll go ahead and pull the CC&Rs and all of the other relevant information. So that way, when you're going into your appointment with a seller, you have that information, or when you're listing it, hey, seller's going to have a payoff, or seller has a lien that they weren't aware of, or these are the CC&Rs. So this is what they should expect to pay when we go ahead and do the HOA transfer. Or I can't think of anything else at those, but they provide a ton of information. So that way, as you guys go into your negotiation, you're armed with the right information. So that way you're getting your seller the best deal. Like I said before, I have left a bunch of his business cards over there. You guys are welcome to pick them up. He is absolutely amazing. We also have a couple of different tools for you guys. It's our Ignite RE portal. You guys, like Shannon was saying, you guys can farm different neighborhoods. You guys can do your advertisement little cards that you mail out, or any of those other online advertisements. It's a really great tool, and he's honestly fabulous at teaching you guys all of the things that are available to you. So if you guys have any interest, I do have some of his business cards over there. One thing Shannon forgot to mention for the people who came in late is, when you guys have a buyer and you guys close with First American, they do get title monitoring for the lifetime they own the property. Why that is important is because, we have so much fraud in the state of Texas, so many, people trying to take what is yours, even if it's your credit or your house. That title monitoring will flag it immediately for your buyer and tell them, hey, something's been filed against your property. You need to know and take care of this. And it could be a lien, it could be a new deed. So I think that's a really great benefit that First American does provide. So before we get out of your hair and let you guys enjoy your bagels, did you guys have any additional questions or questions on? Yes, ma'am.
If you run into Fabatar, are you prepared a 8288 form, or we have to find a CPA to do that?
What's
Fabatar.
Oh, FERPTA.
Mhm.
Okay, so Shannon, do you want to talk about the changes in FERPTA? You can. Do you want to talk about the changes that we've had with FERPTA lately?
Well, we're no longer reporting that anymore. So, yeah. We did that. They rolled it out. They did a whole thing on it. And then I guess it went to the Supreme Court, wherever it went. Yeah. And so there's no reporting.
When start that?
Like a month ago?
A month and a half
Month
ago.
and a half ago?
Mhm.
So there's no requirement.
How does seller and the buyer handle that then?
We don't have to report it. So there's nothing to handle.
So we don't need to hold the money anymore? Oh, wow. We just
Now that's
closed.
subject to change.
Yeah,
I
they,
mean-
might, they
Okay.
might go ahead and pass new legislation.
Right.
But as of right now, this moment.
We halted it. And so we are no longer reporting it.
But if it ever did come back, we did. Do you want to tell them about the new system that they have for First American?
You can.
Well,
I think you were on it more than I was.
Okay, so
Before you go, okay, this
Yeah.
is huge news. Let me ask you. I understand you don't have to report it. We don't have to report it, but would the buyer still owe tax if the seller is a foreigner?
We will still help them in the way of if it is a true FERPTA, but the way that they had rolled it out a month and a half ago, it was completely different. So we're almost back to the old way that we used to report FERPTA, where we will help them, we'll figure out the prices, we'll help send that in. But what was happening previously was if you were changing title, like let's just say Mr. and Mrs. King owned a piece of property and we were going to put it into an LLC and then the LLC was going to sell it, that was triggering FERPTA for everybody.
Oh, okay.
So that's no longer an issue.
Okay.
We've gone back to, I can deed it to my LLC and then turn around and deed it to the end buyer. That's not an issue.
Okay.
But as far as reporting true FERPTA hasn't gone away. It's the new FERPTA that was implemented a month and a half ago that has halted. Does that make sense?
Okay, so I think I understand is that the new FERPTA was requiring you, even when you're changing title, you still have to report. Now you don't have to.
Now we're not.
However, the traditional FERPTA, which is I'm a foreigner, I'm selling it to a buyer, the buyer actually will be responsible for the tax in the future.
Mhm.
So during this transaction, we still have to.
You still
report.
have to report FERPTA, yes,
Got you.
but not how we were doing it a month and a half ago. And maybe that's a new class that we need to put on with Brandon.
Yeah.
You guys
Especially-
want to class, we can absolutely put that on the
Yeah.
schedule and come out. And
We need that as soon as possible because we do
Okay.
deal with a lot of foreign seller.
I will have to get a hold of Brandon and
Yeah.
we will set something up so we can go through all, because there's been
Still
a,
have to do your IRS.
yes.
Yeah.
Yes.
It's just the liability part.
Correct.
Correct. So, like I said, we can go through, we can set an entire class. And if you guys want to set an entire class on water rights, we could take up a whole hour on water rights as well. But any class or any education you guys want or need, we are happy to come out and talk about whatever subject you guys want.
Yeah.
The first is a great starting point. And I'll have Teresa make arrangements with Brandon and we can go through, because there has been significant changes this entire year. We went
Yeah.
from reporting only certain things to having to report everything to not having to report as much.
So another sticky subject was the SB 17. Any progress, any updates later, or do you know,
There hasn't been any updates on that.
or
And
when's
it's,
the next, like,
Okay, you want
I guess when the next ruling or changes that could affect?
hopefully sooner rather than later on that. I would love to see where you guys had a little bit more flexibility in what you guys were able to do. But as of right now, no changes since the last one, and that's not ideal.
Can you verify this? Because I literally read the original law when it came in effect of like the SB 17. I know there's a line there saying that except for primary residence. But I heard other people, even lawyers, say no, it's not true anymore. Even primary residence you cannot buy. So I want to verify that with you.
So I think that's okay. So we can go, let's set a class and go into deep, because there's a lot to explain there and there's a lot to break down. And I'd rather do it right than just give you guys kind of a half answer. But absolutely, if you guys want to set a class on that and we can go over what you guys should be doing and shouldn't be doing, I'd much rather have you guys be fully informed than just give you a.
Yeah.
And we could probably do that in one class. We could do the FERPTA and the.
Oh yeah.
Oh, yeah.
True, true,
Absolutely.
True. Yeah. True. Yeah. Okay. Great. Thank you.
Awesome. I'll go
Okay.
look at the calendar and then reach out back to you.
Okay. Yeah, absolutely.
Okay.
Absolutely. We'd love to come back and host